Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is April 14th, 2022. It is 2 p.m. and we're here today for our weekly business meeting. Before we get started, please join me in a brief moment of silence. Thank you very much. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Thomas, Powers, and Belzer. Joining us virtually, we have Commissioners Irvin and Caston. Today, we have two of our lawyers reading the agenda. We have General Counsel Wessinger Hill and Senior Counsel David Butler.
Okay, thank you, Mr. Chairman, members of the Commission. Good afternoon. The first order of business would be to set the next Commission business meeting, and staff recommends that the next meeting be set on Thursday, April 28th at 2 p.m.
Thank you, Attorney Butler. April 28th at 2 p.m., the Commission will hold its next business meeting.
Thank you, sir. Moving into our utilities agenda, Mr. Chairman, we'd like to ask that the Commission carry over item 1 at the present time, please.
Item 1 will be carried over.
Yes, sir. Moving to item 2. This is in docket number 2005-78C. There is a Fifth Amendment to the interconnection agreement between Bell South Telecommunications, DBA AT&T, South Carolina, and Berkeley Cable Television, DBA Home Telephone.
Is there a motion?
Mr. Chairman.
Commissioner Powers, you have the floor, sir.
Thank you, Mr. Chairman. I move the Commission approve the Fifth Amendment to the interconnection agreement between Bell South Telecommunications, LLC, doing business as AT&T, South Carolina, and Berkeley Cable Television, doing business as Home Telecom. So moved.
Thank you, Commissioner Powers. Commissioners, hearing Commissioner Powers' motion, is there any discussion? Hearing no discussion, we will vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Powers.
I vote aye.
Commissioner Thomas.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, the next item is in docket number 2014-346WS. Before the Commission today is the consideration of the Office of Regulatory Staff's letter petitioning the Commission to issue a procedural directive order requiring the Office of Regulatory Staff to pay Tufusky Island Utility Incorporated $3,451.80.
Commissioners, is there a motion?
Mr. Chairman, before we take up this matter, I would like to note that I am recused and have not participated in any discussions on this item.
Thank you, ma'am. Commissioners, is there a motion?
Mr. Chairman,
Commissioner Thomas.
thank you. On March 24th, 2022, the Office of Regulatory Staff, ORS, requested that the Commission issue a procedural directive order requiring ORS to pay Tufusky Island Utility Company, or Tufusky, a purported undivided 1/4 share the total court costs awarded to Tufusky by the South Carolina Supreme Court as part of the second appeal. ORS asserts that its share would be $3,451.61. As you may recall, Tufusky, ORS, Hay Point Club and Community Association, Incorporated, Melrose Property Owners Association, Incorporated, and Bloody Point Property Owners Association presented a settlement agreement following the second appeal and remand of the issues between the parties. There was no request to extract the issue of the court cost from the settlement agreement, and no motion for reconsideration raised the court cost issue. However, there is no prohibition for the parties to supplement the settlement agreement to handle the court costs separately and set the allocation, and then such supplemental agreement can be considered by the Commission. South Carolina Code Section 58-4-20B specifically prohibits the commission from issuing the order requested by ORS.
Commissioners, hearing Commissioner Thomas's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
I vote aye.
Vice Chair Belzer is recused. Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, item number 4 is in docket number 2008-140A. Staff is presenting for commission consideration today a request for a 30-day extension of time to file annual reports filed on behalf of Kiowa Island Utility Incorporated, South Carolina Water Utilities Incorporated, which include TJ Barnwell, CUC Incorporated, PU Incorporated, Harbor Island, Palmetto Wastewater Reclamation Incorporated, and finally Synergy Utilities LP.
Commissioners, is there a motion? Commissioner Williams.
Thank you, Chairman Williams. I move that the commission grant the request for a 30-day extension of time to file annual reports by Kiowa Island Utility Incorporated, South Carolina Water Utilities Incorporated, consisting of TJ Barnwell, CUC Incorporated, PU Incorporated, Harbor Island, Palmetto Wastewater Reclamation Incorporated, and Synergy Utilities LP.
Commissioners, hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 5 is the request of Dominion Energy South Carolina Incorporated to file its First Amendment to the Renewable Power Purchase Agreement with Eastover Solar LLC, along with the request for confidential treatment of certain portions of the agreement and docket number 2021-185E.
Commissioners.
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. I move that the commission grant the request for filing of the First Amendment to the Renewable Power Purchase Agreement between Dominion Energy South Carolina and Eastover Solar LLC, along with the request for confidential treatment of certain portions of the agreement.
Commissioners, hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, in item number 6, we have a request for withdrawal on behalf of the complainant, Brenda McAllister, to withdraw her complaint filed against Dominion Energy South Carolina Incorporated. And this is in docket number 2022-121E.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Thomas, you have the floor, sir.
I move that the commission grant the request of Brenda McAllister to withdraw her complaint.
Commissioners, hearing Commissioner Thomas's motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Powers.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Utilities item number 7 is the motion for Pro Hoc Vici admission of Attorney James H. Jeffries IV on behalf of Piedmont Natural Gas Company and docket number 2022-89G.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Thomas, you have the floor, sir.
I move that the commission grant the verified application for admission pro hoc vici of James H. Jeffries IV, Esquire, filed on behalf of Piedmont Natural Gas Company, Incorporated.
Commissioners, hearing Commissioner Thomas's motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer. Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, the Office of Regulatory Staff has asked that item number 8 in docket number 2022-126G be carried over.
And Mr. Chairman, I'm sorry.
Yes, ma'am.
I'm sorry, I didn't wait for any, is item number 8 carried over?
It depends on what you're about to say.
No, sir.
Oh, okay. All right, so the staff's request is item number 8 to be carried over.
Yes, sir.
Item number 8 is carried over.
Thank you.
I'm sorry, I just jumped the gun.
Oh, okay. No
With-
worries.
With regard to item number 9, it is the motion of defendant company Strata Audubon LLC and Strata Viridian LLC requesting a 30-day extension of time to file a responsive pleading to the complaint in docket number 2022-84WS.
Commissioners, is there a motion?
Mr. Chairman, I'd like to make a motion.
Commissioner Powers, you have the floor, sir.
Thank you, sir. I move that the commission grant the motion of the defendant respondents for an extension of time until May 4th, 2022 to file a responsive pleading to the complaint in this docket.
Commissioners, hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, item number 10 is in docket number 2022-74E. This is a request by Dominion Energy South Carolina Incorporated to decrease its rate rider related to pension costs from a negative .00020 to a negative 0.00073 cents per kilowatt hour without notice and hearing.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
thank you, Mr. Chairman. I move that the request of Dominion Energy South Carolina Incorporated to decrease its pension rider from .00020 to .00073 per kilowatt hour without notice of hearing be granted. Dominion Energy shall continue filing its quarterly updates through April 2023 and shall alert the Commission and ORS of any potential intra-year adjustments necessary to balance pension rider collections from customers. So moved.
Commissioners, hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 11 is in docket number 2021-88E. It is the letter of Carolina's Clean Energy Business Association requesting a status update regarding the order in this docket.
Vice Chair Belzer, I'm going to pass the gavel to you, ma'am.
Thank you, Mr. Chairman. Are there comments or discussion on this item? Motion?
Vice Chair Belzer, I have a motion, ma'am.
Please proceed, Mr. Chairman.
Commissioners, I move that in docket number 2021-88E, the commission issue its order no later than May 2nd, 2022. So moved.
Thank you, Mr. Chairman. Commissioners, you've heard the motion of Chairman Williams. Is there any discussion or questions? Hearing none, we'll proceed to a roll call vote. Chairman Williams?
Aye.
Commissioner Powers?
Aye.
Commissioner Carolee Williams?
Aye.
Commissioner Caston? Commissioner Caston?
Aye.
Commissioner Irvin?
Aye. Aye.
Commissioner Thomas?
Aye.
And I vote aye. The motion passes.
Okay, item number 12 is in docket number 2005-83A, and staff presents for commission consideration a timeline for issuance of commission orders.
Item 12 is carried over to until our next commission business meeting.
Okay. Thank you, Mr. Chairman, members of the commission. That does complete today's utilities agenda. Moving on to the motor carrier agendas. Item numbers 1 through 12 may be taken together. All are involving Class C authority, and I will briefly review those for the commission's consideration. Item number 1 is an application of Simmons & Sons Trans LLC for a Class C non-emergency certificate. 2 is the application of Port City Ambulance Service LLC for a Class C non-emergency certificate, and that's in docket number 2022-124T. Number 3 is in docket number 2022-123T. This is the application of Coastal Motor Coach LLC for a Class C charter bus certificate. Number 4 is docket number 2022-122T, which is the application of Angelic Touch Transport LLC for a Class C stretcher van certificate. Number 5 is in docket number 2022-127T. This is the application of Envision Healthcare Services LLC for a Class C non-emergency certificate. Item number 6 is docket number 2022-128T. The application of Joppa Ed LLC for a Class C non-emergency certificate. 7 is the application of 12-4 Transportation LLC for a Class C non-emergency certificate. 8 is docket 2022-131T, application of Zoom 45 Transportation LLC for a Class C non-emergency certificate. Item number 9 is the application of Travis Mitchell for a Class C taxi certificate under docket number 2022-130T. Number 10 is docket number 2022-133T. It's the application of State Line Medical Transportation LLC for a Class C non-emergency certificate. Item 11 is docket number 2022-134T, which is the application of Coastline Entertainment LLC for a Class C charter certificate. And 12 is under docket 2022-135T. This is the application of Ladia One Limo for a Class C charter certificate.
Commissioners, is there a motion?
Chairman Williams, this is Commissioner Caston. I'd like to make a motion.
Commissioner Caston, you have the floor, sir.
I move that the applications for Class C authority and items numbers 1 through 12 be approved as listed by Mr. Butler. I so move.
Thank you, Commissioner Caston. Commissioners, hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer. Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, item number 13 is in docket number 2021-385T. It is the request of All American Relocation Incorporated, their application for sale, transfer, or lease of its Class E household goods certificate number 6003 from Charlotte Van and Storage Company, Inc., and its request for approval of the bill of lading as currently written.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Thomas, you have the floor, sir.
I move that the commission approve the application of All American Relocation Incorporated for the transfer of a Class E household goods certificate of public convenience and necessity from Charlotte Van and Storage Company, Inc. Further, I move that the commission accept the bill of lading as filed.
Commissioners, hearing Commissioner Thomas's motion, is there any discussion? Hearing none, we will vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other commissioners, items number 14 and 20 on the agenda are both requests to amend and change the name of a business on their certificate. Staff would recommend that these items be taken together, and I will review the requested amendments briefly with the commission. Item number 14 is in docket number 2021-150T. It's a request of Greenville Executive Limo Service, LLC, DBA Long Boy Limo, to amend its Class C Charter Certificate number 9576A to read Greenville Executive Limo Service, LLC, DBA GVL Limo. Item number 20 is in docket number 2011-39T. And it's a request of Anime Grant, DBA Grant Limo Taxi, to amend its Class C Taxi Certificate number 8376 to read Grant Limo Taxi, LLC.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Irvin, you have the floor, sir.
thank you, sir. I move that the commission approve the requests for name changes on the certificates listed in both item numbers 14 and item number 20, as is outlined by Mr. Butler. So moved.
Commissioners, hearing Commissioner Irvin's motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Commissioners, item number 15 on your agenda is in docket number 2000-141-T. It is the request of Jimmy Coates doing business as Greenwood Moving and Storage for reinstatement of its Class E Household Goods Certificate number 9705-B.
Commissioners, is there a motion?
Mr. Chairman,
Commissioner Irvin, you have the floor, sir.
thank you. I move that the commission grant the request for reinstatement of certificate number 9705B for Jimmy Coates doing business as Greenwood Moving and Storage, subject to all commission rules and regulations. So moved.
Commissioners, hearing Commissioner Irvin's motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Commissioners, items number 16 and 17 are both requests for extensions of time for certain companies to file annual reports in the same administrative docket number 2008-141A. Staff would recommend that these items be taken together, and I'll review the requested extensions briefly with the commission. Item number 16 is a request of Coleman American Moving Services, Inc. and Covan Worldwide Moving, Inc. for an extension until June 1st, 2022 to file its annual report. Finally, item number 17 is a request of Forest Hills Transfer and Storage Incorporated for an extension until May 31st to file its annual report.
Commissioners, is there a motion?
Mr. Chair,
Commissioner Irvin, you have the floor, sir.
thank you, sir. I move that the commission approve the request for an extension of time to file annual reports in items numbers 16 and 17 as listed by Mr. Butler. So moved.
Commissioners, hearing Commissioner Irvin's motion, is there any discussion?
Mr. Chairman,
Commissioner Thomas, you have the floor, sir.
I just wanted a little clarification here. The docket number, I believe, is 2008-140A. I may have heard a different docket number, but I think for the record, it's 2008-140A.
Yes, Mr. Chairman and Commissioners, that would be correct. It'd be 140A.
All right, Commissioner Thomas, does that answer your question, sir?
Yes, sir.
Commissioners, is there any further discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 18 on your agenda is in docket number 2021-246T. It is a request for extension from Royal Crowns Transport Service LLC, requesting additional time until June 30th, 2022 to comply with commission rules and regulations.
Commissioners, is there a motion?
Mr. Chair.
Commissioner Irvin,
Thank you, Mr. Chairman. Mr. Chairman, I move that the commission grant the request of Royal Crowns Transport Service LLC for an additional extension of time until June 30, 2022 to comply with commission rules and regulations. So moved.
Commissioners, hearing Commissioner Irvin's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Commissioners, item number, gee whiz. It's been a long one. Item number 19 is a request to suspend in docket number 2017-224T. Gregory Jenkins Trucking LLC, DBA G&G Transportation, asks the commission to suspend its Class C non-emergency certificate number 9354 until March 28, 2023.
Commissioners, is there a motion?
Chairman Williams.
Commissioner Caston.
I'd like to make a motion, please.
You have the floor, sir.
I move that the commission grant the request of Gregory Jenkins Trucking LLC, doing business as G&G Transportation, to suspend its Class C non-emergency certificate number 9354 until March 28th, 2023. I so move.
Commissioners, hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Commissioners, the next item for your consideration is item number 21. It is in docket number 2004-171T. It is a request for reinstatement by CNF Charter Service LLC of its Class C Charter Bus Certificate number 0147-A.
Commissioners, is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. I move that the commission grant the request for reinstatement of Class C Charter Bus Certificate number 0147A for CNF Charter Service LLC, subject to all commission rules and regulations.
Commissioners, hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Commissioners, item number 22 is a request to amend its tariff by Jordan River Moving LLC, DBA Jordan River Moving and Storage, and this is under docket number 2022-61T.
Commissioners, is there a motion?
Chairman Williams, Commissioner Caston.
Commissioner Caston, you have the floor, sir.
On April 7th, 2022, and Directive Order number 2022-237, the Commission voted to carry over this docket until we receive the results of the ORS impact study. On April 11th, 2022, the Commission received correspondence from ORS stating, in part, Jordan River Moving is in compliance with all Commission rules and regulations. Based upon a review of the entire record, including the company's justification for the amendment and the ORS study, I move we grant the application of Jordan River Moving to amend its tariff. I so move.
Commissioners, hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 23 on your agenda is the request of Upward Endeavors LLC, doing business as 2 Men and a Truck of Greenville, requesting to amend its tariff along with a request for waiver of publication. It is in docket number 2022-66T.
Commissioners, is there a motion?
Commissioner, Chairman Williams, this is Commissioner Caston. I'm sorry, I'd like to make a motion.
Commissioner Caston, you have the floor, sir.
On April 7th, 2022, excuse me, in Directive Order number 2022-236, the Commission voted to carry over this docket until we receive the results of the ORS impact study. On April 11th, 2022, the Commission received correspondence from ORS stating in part, Upward Endeavors is in compliance with all Commission rules and regulations. Based upon a review of the entire record, including the company's justification for the amendment and the ORS study, I move we grant the application of Upward Endeavors to amend its tariff. I so move.
Commissioners, hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
I vote aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas. Aye. Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, the last item on the transportation agenda is item number 24. It is the motion for reconsideration of Commission Directive Order number 2022-238 and docket number 2021-364T by NBF Beaufort LLC, doing business as 2 Men and a Truck of Beaufort.
Commissioners, is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. On April 7th, 2022, in Directive Order number 2022-238, the Commission voted it is reasonable to require NBF Beaufort to comply with Regulation 103-854 of South Carolina Code of State Regulations in making a motion for reconsideration. On April 8th, 2022, NBF complied with the regulation and filed a motion for reconsideration of Order number 2022-156, which approved in part and denied in part the company's proposed amendments. More specifically, NBF Beaufort asked for reconsideration of the decision of the Commission to deny the request of the company to require a customer to present a claim for damages within 96 hours of the move. NBF Beaufort also seeks reconsideration of the Commission's decision to hold it is reasonable for the company to use a full replacement coverage provision approved by the Commission. I move that the Commission grant the motion for reconsideration of NBF Beaufort LLC, doing business as 2 Men and a Truck, Beaufort. I further move that the Commission approve the company's proposed amendments to its tariff and bill of lading filed on December 22nd, 2021.
Commissioners, hearing Commissioner Williams' motion, is there any discussion?
Mr.
Chairman Williams.
Who drew first?
Go ahead.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Chairman, usually when there's a reconsideration of something, it's when there's been a requirement for a mover or someone to accomplish something that hadn't been done at the time, or something else to be filed, or something to be done, or some change in circumstances, or an error of law on our part. We voted on this, and I think there was a general acceptance that 4 days was not enough. I think there was a compromise in this that was fair. I would have to either offer a compromise of 14 days as a friendly amendment, if Commissioner Williams would accept that, as to the full replacement coverage provision, I think we consider that fairly, and there's been no evidence or anything brought to us that shows that anything on that should be changed. And I would ask if she would accept those two things as a friendly amendment. If not, I just cannot support her motion. Thank you.
Commissioner Williams.
Thank you, sir. I bring you this recommendation for two reasons. With regard to the claim limit for up to 46 hours and 4 days, part of what is being brought to us in addition is that this is a part of a chain, 2 men in a truck, and they currently use 4 days is their standard for that particular franchise. In addition, our staff has done some research over the past several weeks, and in looking at the agreements that we have made for transportation provisions like this, we have agreed in the past 19 months that all of us have been serving 7 times for companies to have up to 4 days to make those, for customers to have up to 4 days to make those claims. We've done that 7 times. My recommendation is that we reconsider this so that we offer some some consistency with regard to that claim number in the absence of any rulemaking that gives us a consistent standard that we can use. And with regard to the full value replacement coverage, in further considering this request, what I believe to be the law in the case is that this company is providing the minimum standard that is required, which is the 60 cents per pound, and that this is an option that customers have that they can choose to request full replacement coverage. This is an item that the company previously had specified, but of course those numbers change as insurance provisions change. And so my recommendation is that we allow them, this is also a franchise agreement within the 2 men in a truck, and they use the term, they provide full replacement coverage upon request. So I feel like they've met the minimum standards, and that's the basis upon which I offer the reconsideration. I reflect on your request, and I wish that I could take them as friendly amendments, but based on my perspective, I'd like to keep the motion as is.
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
I would only add that last weekend, approximately 10 days ago, I moved my son using 2 men in a truck. And I went over last night to visit him, and there are still boxes in the dining room on the floor, unopened, unchecked, and he's doing his best. When you work all day and you're going through something like that, it just takes time. And I'm just thinking of the consumer, not of what the company likes. Thank you.
Commissioners, any further discussion? Fellow commissioners, I would like to offer this for the body's consideration. I think it goes without saying that we have, as a body, made decisions regarding how long or what is the reasonable amount of time a shipper should have to report damage to goods moved to the carrier. While it comes across as a simple question, levels of complexity are added when you consider what it's like to move, which I've never used a private moving company, but just hearing Commissioner Powers talk about his personal experience and the experience of his son, I can put myself in his shoes and in his son's shoes, especially recently having a son of my own. How long would it take me to go through all of my belongings if I hired a private moving company to move from point A to point B, how long would it take me to go through all of my stuff? And I have no idea because I've never done that before. I guess the real question for me in my mind is whether or not the consumer has an understanding of what their responsibilities are under the agreement that they enter into with the carrier. Considering the number of carriers that offer moving services under our jurisdiction, one could argue that if a customer did not believe that 4 days or any amount of time was not long enough for them to go through their materials to determine whether or not the carrier damaged the materials in transit, that they could seek another carrier and use the market to make a determination as to who best would meet their needs. On the other hand, the question is whether or not the customer is sophisticated enough to go through that contract and really appreciate that they would only have 4 days or more or less. And so here we are trying to figure out what's reasonable. Commissioner Williams, I have a question for you if you would entertain it.
Absolutely.
My question is more towards the concerns that you have regarding the Commission's decisions in the past 18 to 19 months. Is the concern more so that we've made rulings that are more or less than 4 days, or that you believe 4 days is a sufficient time for the shipper to review their goods to make a determination as to whether or not damage has been done?
I wish I was wise enough to know the answer to that last question. So it is definitely not that. It is more about wanting to be consistent to every applicant. And just in looking at the past 19 months, had there been a minimal number of cases where we had granted, the allowance for greater than 4 days, I might not have felt as strongly about this particular motion. In other words, I don't know what the right number is, but in the absence of commission rulemaking where we have studied and evaluated and made a decision, I don't feel that it's fair to hurt this particular applicant when we have granted this number of days in the past.
Understood.
Mr. Chairman.
Commissioner Caston, I will recognize you. I have a few more questions. One for Commissioner Powers. Commissioner Powers, I understand your perspective, and I spent time in my career representing the little guy, so I understand that perspective. But this carrier could consider themselves the little guy as well, being a small business. My question to you, Commissioner Powers, if you would entertain it, is it not fair for a shipper and a carrier to enter into an agreement if the language regarding the deadline or the timeline for reporting damage is conspicuously included in the agreement, and they understand that they have that amount of time, and if they don't think that's reasonable for them, say in your case or your son's case or anyone's case, that they then find another carrier? Is that not reasonable?
Mr. Chairman, thank you for the question. First, let me clarify one thing. When I said I moved my son the other week, it was a two-in-a-truck company. It was not this company. And I will say on behalf of that company, they did a very fine job. As far as the move, as you say, you haven't done it, but I can tell you when you get ready to move, it's always that frantic last moment. You're packing that last box. You're looking for this, that, and the other. And the contract is presented to you with letters about this big, and it's on the hood of the truck when they're getting ready to go. And no, I don't think the consumer, number one, has time to read it, or number two, under the anxiety of the move itself, the hurry that you put in. I mean, they don't want to wait around when they're moving, and you don't want them to because you're paying by the hour. I don't think it's that they do know. Some consumers may know. I know now what my time limits are, and I know to call them ahead of time, discuss it, and tell them to please hurry when you're moving, so it won't cost me as much money. But there may be some sort of process that needs to be done. You know, the standard in the industry with some moving situations, the federal thing is 90 days. But no, you don't have time to look at it, and it's one of those fine print things that even lawyers don't read many times when they have the opportunity, because it's just not time and it's just not feasible. That's my concern, and I don't know, as Commissioner Carol Lee Williams says, she doesn't know the standard. I don't know the standard. I just don't like 4 days, and this all needs to be decided or worked out, and let's get something that's, we have been all over the map. Let's get something that is proper and to the benefit of both sides of a moving company, the consumer and the mover. But we're not there yet, and that's just where I am. And I say all of that respectfully to both Commissioner Williams and to the rest of the panel. Thank you.
Thank you, Commissioner Powers. Commissioner Caston.
This may be the most plowed ground we've plowed since I've been here. And I absolutely understand what Commissioner Powers is saying. I absolutely understand what Commissioner Williams is saying. And generally, I believe these businesses are reasonably competitive. They certainly compete with each other. And as it has been pointed out, and I agree with Commissioner Williams that the staff did a good job of pulling together, I guess, a good table showing, you know, what has been approved. And what concerns me is it is a competitive business. And I don't know how much this affects it, whether it's 4 days, 14 days, 30 days, but there is a difference. And I guess my general feeling is, it being a competitive business, and since we really don't have a particular standard, we haven't established one that I know of, that, you know, if the business wants to use 4 days and feels like that's in its best interest, another business may think marketing their 30-day is better business. You know, I don't know the answer to that. But I don't feel comfortable having made decisions that have this part of it kind of all over the place. I agree. I wish there was a standard. We don't have one. All this said, I have pretty much agreed to the 30 days, the 14 days. But if all of this franchise, if my understanding, Commissioner Williams, they have other franchises in the state that have this particular time frame. Is that correct?
Commissioner Caston, that is what the applicant asserted in their request for reconsideration. What I see from the staff's research just from the past 19 months is, I believe there was another 2 men in the truck that we looked at in that time frame that was a 4-day. But I'm scanning right now. I see it. There's one other 2 men in a truck that we permit on February the 10th. We allowed 4 days, and the only 2 men. There've only been 2 two men in a truck applications in the 19 months that I considered.
Well, I guess whether it's two men in a truck or any other haulers that have already approved 96 hours or 4 days, you know, it exists. So I would prefer this be a lot simpler than it is, but I say all that for this reason. I am inclined to agree with your motion just because it's competitive business. I don't want to do anything that's not well defined by our statutes or our regulations that could hinder that. That's truly where I'm coming from. That's all I had to say about that, Chairman Williams.
Mr. Chairman.
Commissioner Irvin.
Thank you, Mr. Chair. You know, I know there's potential good about being consistent unless you're consistently wrong. And I think that we have been consistently wrong in this regard. These are what's in the law called adhesion contracts. And as Commissioner Powers did a good job of explaining, you don't have time to read the fine print. It's stuck in front of your face with a pen. It's ready to sign. And nobody reads these fine print contracts. That's why they're called adhesion contracts. And what they mean is you're stuck like a glue. You're stuck with those terms. And if you have damaged goods and you would discover it the next weekend, 6 or 7 days later, it's on you. And do you think people really are buying full insurance coverage? Of course not. You know, the thought is to sign the form, get in the car, and follow the truck. And so I don't think it's fair to the consumer to be stuck with a bad contract term. And we have the authority and the discretion to do something about that. And so I agree with Commissioner Powers. We ought to stand up for the citizens of our state and protect their legal interest. They'll have no opportunity to do that when they sign the form, get in the car, and follow the truck. Thank you, sir.
Commissioners, any more discussion?
Chairman Williams, part of what I heard Commissioner Powers saying is that he didn't support the reconsideration. Should we separate the motion and vote on the reconsideration first?
Well, it's your motion. If you, I don't think that's necessary.
Then let's don't do it.
All right.
That's fine.
So I just have a few more comments and observations I'd like to make as I think through this. I think everyone is right. So let me start there. Everyone, I believe all the comments that were made were they have a level of righteousness to them. And so as a decision maker for me, I have to determine who's the most right and what's the best practice. And this is what I'm visualizing as I'm hearing what everyone is saying and weighing this in my mind, the options available to the citizens, if you will, because we have to weigh both sides, the shipper and the carrier. Many times, if not all times, both are citizens and both deserve fair and impartial consideration and treatment from the commission. And so if a shipper has the ability to decide and choose, select a carrier from the market to move their household goods, there's a certain level of freedom and independence that they possess with that choice and with that decision. Well, what choice and what freedom and what decision does the carrier have? And what strikes me, Commissioner Williams, is because we have been inconsistent, to put it nicely, and because we don't have a rule promulgated through a regulation, it's fair to say that the carrier would have to almost guess as to what is the appropriate amount of time. Now, they could go with 9 months. I think that's on the standard or the uniform bill of lading. But 9 months and 30 days, that's two totally different standards. And so as I consider the shippers, or excuse me, the carriers' freedom, independence, ability to create the world they want to live in, this question arises in my mind. Is the commission standing in the way of a free market, if you will? Are we standing in the way of a business owner attempting to put their best business plan or offer their best business plan to the market and try to make a living?
Mr. Chair, would you yield for a question?
Yes, sir. I yield.
Since you made a reference to, are we interfering with the free market? Isn't it true that this is a regulated market, which is why we as regulators have to pass upon it?
Absolutely true.
Okay. And isn't it also true we have to balance the interest, just like you said, between the consumer, the customer, the household owner, and how he's going to be treated versus how the carrier is going to be treated. And I agree with you. But who has the power in this equation? Who's drafting the terms of the contract? It's the shipper. And the consumer has no opportunity to respond. Are you going to cancel a move based on a contract term that can't be changed? Of course not. You're stuck. That's why it's an adhesion contract. You're stuck. Are you going to hire a lawyer to negotiate this contract before the move? Of course not. People just aren't that sophisticated in terms of their legal dealings. And that's why it's a regulated industry, and that's why we have a duty to protect the public. And I would encourage you all, so let's stay at a standard of 14 days and be consistent with it. I think Commissioner Powers offered that as a very reasonable compromise. Frankly, I'd prefer longer. I'd prefer 30 days, but 14 days is reasonable. It gives people time to unpack and check, see if they've got any damaged goods. And I can tell you, having moved several times, I've had damaged goods, and I had to file a claim. And thankfully, I wasn't limited to whatever this is, 64 hours, because I didn't find it until later. So keep that in mind as you vote on this, and let's stick with 14 days as a standard. Thank you.
Thank you, Commissioner Urban, and you make a very good point, and I would ask that if you would entertain a question from me.
Yes, sir.
Again, I will state again, I think everyone is right. Nothing you said I don't believe is wrong. I just want you to consider this and give me your thoughts here. In the South Carolina regulatory scheme, we have the Office of Regulatory Staff, and the Office of Regulatory Staff is charged with protecting or representing the public interest. And if I'm not mistaken, Commissioner Williams, they have found this company fit, willing, and able, have they not? So if the agency that is charged with protecting or representing the public interest has found this company fit, willing, and able, they have an employee that Thomas McGill that goes through the carrier's filings and reports and so forth and so on. I don't think there's a letter in opposition to this filed by the Office of Regulatory Staff. Is there, Commissioner Williams?
I'm not aware of one. This was just an amendment to a tariff.
Right. I don't think there's a letter filed in opposition. How do we balance that, Commissioner Urban?
Sure. Thank you. Um, Here's what I say about that. The Office of Regulatory Staff is tasked with performing an investigation, which, as you know, includes a site visit to see if that carrier is, quote, fit, willing, and able under the statute. Then they send us a recommendation. We still have the ultimate responsibility to review the entire tariff terms. They didn't tell, the ORS doesn't tell us that the tariff is reasonable. I don't believe that's what the letter says. They say that the shipper is fit, willing, and able to load a truck and head down the road based on their driving record and their insurance coverage and so forth. But we ultimately have to decide, are we going to hoist an adhesion contract on some 5 million people when we're the only ones that know that's wrong? They will never know until they have damaged goods and can't collect. So we talk sometimes about an uneven playing field. This is an uneven playing field. You're pitting innocent consumers against an industry that can get insurance coverage, and they do. And I understand why they want to limit their coverage terms, but there has to be a balance. And that's all I'm saying. We need to balance the interests of the parties. One party here is disadvantaged because they don't have a lawyer. They don't have an opportunity to read the fine print, and then they suffer a loss and they have no recourse whatsoever. And if you consider all those factors, it's not fair. They deserve 2 weeks. And if they don't unpack within those 2 weeks, then the burden should shift, but not before. Thank you.
All right, commissioners, any further discussion?
Mr. Chairman,
Commissioner Thomas.
well, I have to agree with you. Everyone's right. But I don't know what the appropriate fix is, but I think a standard should be a standard. And I believe that the way to get the standard corrected is to go through the drafting of the regulations. Unfortunately, that's a time-consuming process. But then once that's done, it does create the standard. And just trying to deal with this on an individual basis over and over again, I just don't think that's right. And I hope that we are doing what it takes to get this covered under regulation. That's what I would like to see happen. Thank you.
All right. If there's no further discussion, before we vote, I would like to say it's good when everyone is right. That means we all have an easy decision to make. We'll start voting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye on the motion for reconsideration.
Commissioner Caston.
Aye.
Commissioner Irvin.
No.
Commissioner Thomas.
Aye.
Commissioner Powers.
No.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, that completes the motor carriers agenda and indeed all the agendas before the commission today.
General Counsel Wessinger Hill, Senior Counsel Butler, thank you. Commissioners, if there's nothing else, we are adjourned.